There's no other eviction process anywhere in the country like Nevada is. Usually by the time of the eviction, the relationship between the landlord and tenant is not great, and so.
Why would a landlord refuse money?
Oh my God, Alexis, this is the big question we've been asking.
Why?
Why would some landlords say, I just want the eviction, I don't want the money? Well, so you would rather have the tenant walk away?
What if you could get both?
Yeah.
Because they probably want to leave too.
Because realistically, the landlord's never going to get that money.
Right.
They will never get that money.
Right.
So.
Well, welcome everybody to today's episode of the Our Nevada Judges Perspective series. Today we have Jim Berchtold. We are at the Legal Aid Center of Southern Nevada, and we are talking about tenant rights in 2022 now. Jim, welcome. Thank you for allowing us. Thank the Legal Aid Center for allowing us to be here and talking to us.
Happy to be here.
So why don't you just tell us a little bit about yourself, of course.
So I am the directing attorney for the Consumer Rights Project at Legal Aid Center of Southern Nevada. So it's kind of a mouthful, but it's basically the Consumer Rights Project is an umbrella project for a number of sub-projects, one of which is a new housing project that we started during the pandemic because the community had a need.
A huge need. So today we're going to talk about tenant rights in 2022. So there's been a lot of things, of course, that have happened in 2020, 2021, and people are wondering kind of where we're at now. So I think my first questions are, we know that there was a lot of help. The federal government had come up with some acts to help tenants. There's the CHAPS program here in Nevada. Some of those things have expired and some of them are still existing. So I think the most important part, what is still existing?
Okay.
What can tenants still look for help from in this COVID day and age?
Okay, yeah, that's absolutely right. Over the course of the last 2 years, there have been a lot of programs that have come and gone. Starting clear back in March of 2020, Congress started enacting legislation, but everything was kind of done in 4-month chunks because everybody thought, oh, this pandemic will be gone in 4 months. And so every 4 months, something would be revised. And so it's been impossible for tenants to keep abreast of what is happening and what they need to do to protect themselves. So right now, at the federal level, most things have gone away. So if tenants hear anything about the CDC order or anything, all gone. Really, the only thing that's remaining at the federal level, there are some lingering protections from the CARES Act if the tenant lives in a multifamily property, so basically a complex, and that property is either in forbearance, has a federally backed loan that is in forbearance, or is in repayment of that forbearance. Then there are some protections, but that's a really narrow slice of the pie.
Sure, and how would a tenant even know if their landlord is among those people?
Well, Alexis, that's a great question. So there's really no way to tell. There are some lookup tools online where a tenant can go in and plug in their property address, and it will show them whether that property has a federally backed mortgage. But it doesn't really tell them whether that mortgage is in forbearance or in repayment. So what's supposed to happen is the landlord is supposed to give the tenant a notice saying, this is what's happening and these are your rights. We're hopeful that some landlords are doing that, but some, I'm sure are not. So if the property is in one of the properties that is in repayment of a forbearance, the tenant, if they're being evicted, might receive a 30-day notice of non-payment, which is a very weird thing. It's not the normal non-payment notice in Nevada, but that's what that means. That 30-day notice means that property is in forbearance.
Got it. So if you receive a 30-day non-payment of rent,
it's real.
It's real, and it probably means that your landlord is of this narrow little class of landlords that is in forbearance.
Correct.
Interesting.
Yeah.
So, and it's different than a 30-day no-cause notice.
Totally different. Yes.
So you have to be careful about what notices are getting received.
Yes,
always.
and the 30-day notice will tell the tenant what action they need to take to protect themselves. So every tenant should read the notice carefully. Whatever the notice is, read it carefully. So that's protection at the federal level. At the state level, that's really where all the action's happening, right? So at the state level, the big protection that's in place is AB 486, which was passed in, I think it was June of last year, I believe, but it was immediately effective, so that is in effect right now. And that is the bill that is protecting tenants right now. So rental assistance is widely available, right? I think Congress has allocated some $45 billion in rental assistance across the country. Nevada is getting $480 million in rental assistance, and that's likely to go up because right now the Treasury is looking at other states who aren't using that money and is going to reallocate it to states that are still in need and are doing a good job of getting that money out on the streets. So there's rental assistance available. The problem has always been the process for getting that rental assistance wasn't marrying with the process, with the eviction process. The eviction process, really, really fast. Rental assistance process, not fast at all. So how do you link those two things together? So that's kind of what AB 486 does, and it really does a couple of important things for tenants. So it gives the tenant two new affirmative defenses in an eviction case. The first defense is, I have applied for CHAP. CHAP is the rental assistance program. I have applied for CHAP, my application is pending, and if the tenant raises that defense, they should not be evicted while that application is pending. The second defense is, I applied for CHAP and I've been approved for CHAP, but my landlord's refusing to take the money. In which case, again, no eviction. So those are the two big defenses. AB 486 also incorporated the mediation program, eviction mediation program that had already been in effect, but it sort of brought it into this whole process so that if a tenant, when they file with the court, if they say, I want to mediate, then their case is going to go to mediation and they'll have the opportunity to try to sit down with their landlord and work something out. So that's the big protection. But the tenant has to apply for rental assistance and has to take action in response to that eviction notice.
And so taking action in response to the eviction notice means filing their answer in the court.
Filing the answer with the court.
And I know a big question that a lot of our Nevada judges, viewers ask is, or they get confused about, I guess, is the order of timing of things. Because in the normal civil lawsuit process, you file the plaintiff files a complaint, and then it gets served, and then the defendant files an answer. Where in the summary eviction process, it's backwards, right? Why don't you explain to our viewers a little bit about that?
So it really is the only process, legal process I know of, where the person who's being sued has to take the first action in the court. There's no other eviction process anywhere in the country like Nevada's. So the way every eviction starts in Nevada is the tenant will receive a notice of eviction. That notice will tell the tenant what the landlord believes they're doing wrong, why the landlord thinks they have a basis for eviction. And that notice, the period of that notice, whether it's a 7-day or a 5-day or whatever, that notice is the tenant's opportunity to do something. So the tenant can do a couple things. They can do nothing, in which case they will probably get evicted. They can comply with the notice, meaning let's say it's a lease violation notice. They can fix the lease violation. Or they can go down to the court during that notice period and file an answer with the court and say, I disagree with this notice and here's why. These are the defenses I'm raising. And the very act of filing that notice guarantees them a hearing. No eviction can take place until the tenant has the opportunity to appear in front of a judge and make their argument.
And if it does, then you have a whole different remedy that you can apply for, but we can talk about that later. So at the answer stage, they've already been served notices, they've gotten at least probably 2, more than likely, right?
Yes.
They should get 2. It always starts with 1 notice. That's the initial notice. It's either a you didn't pay rent notice, that's the 7-day notice, or it'll be the no cause notice, which is a 30-day notice, or it could be a nuisance notice, which is a 3-day notice, and there's a couple of others, I think a 5-day notice.
Lease violation notice.
Lease violation notice. I think there's also a squatter's rights for landlords. There's information for landlords and squatter's rights. I think that's the 4-day notice.
Yeah, there's a couple of kind of unique notices, one for squatters, one for foreclosure, that you don't see very much.
Right.
For tenants, it's usually, those are the big ones.
3, 5, 7, or 30.
Yeah, and the important thing to remember for tenants is the 7-day notice is a 1-part notice. That's the notice for non-payment of rent. That's the most frequently used notice. That's a 1-part notice. The tenant's not going to get another notice after that. Every other notice is 2 parts. The first part will tell the tenant, this is what you're doing wrong, and this is what you need to do to fix it. The second notice will say, you didn't fix it, or you didn't comply with the first notice, now you're in unlawful detainer, and I'm going to move to evict you. That it's during that second notice period that the tenant can go down and file an answer with the court to protect themselves.
And again, if they don't,
They will be evicted.
and the reason for that is because the landlord then has to go in and file their complaints.
Yep.
And if there's no answer on file, the justice court, the eviction court judges, or judge, I guess, there's really only like one of them really over there. The eviction court judge will automatically grant it, essentially. And then the court will send over the order to the constable.
Yep, that's absolutely correct. If there's no answer on file from the tenant, then the court assumes the tenant's not defending the case. So when the landlord comes in and files a complaint, then the court says, oh, the tenant's not doing anything, so landlord gets the eviction, and it happens all automatically without any involvement of the tenant at all.
Right. I have heard through the grapevine that occasionally some tenants are told that they just should keep their answer very simple and not attach anything or anything like that. Do you think that's good or bad advice?
Well, I think it's a strategy, probably not the strategy I would use. If the tenant has a good defense, there is no downside to getting that information in front of the judge. So let's say, for example, that the tenant has the defense under AB 486 that I've applied for CHAP. Why would you not print off from the website, go on the CHAP website, print off your application that says your application has been received and you're pending assignment to a caseworker, and attach that to your answer? Why would you not do that? So I think the more information, the better. I think where tenants sometimes get astray a little bit is they want to tell a whole story. They want to tell their big long story because that's what matters to them, and they want the judge to know everything. But not everything is important. They have to focus it, and they have to keep it relevant to why the landlord is trying to evict them.
Right.
And if they do that, then there's no downside to giving the judge as much information as they can.
Right. And one of the reasons for that is really because the eviction court is just about possession.
Correct.
All the court is deciding in the eviction court is whether or not a tenant can stay in the property or not.
That's right.
And
That's
if there's a valid basis for them to not be paying rent, or there's a valid, basically really it's not even a valid reason for them not paying rent. Really is the landlord's notices, are they valid and should they be honored?
That's correct.
Right? And so a tenant has to come in and have specific evidence as to why those notices that the landlord served them with should not be honored.
That's absolutely correct. Could not have said it better. Yeah. At the end of the eviction case, the judge is just going to do one thing. He's going to say either landlord, you get the property, or tenant, you get the property.
Right.
Eviction denied or eviction granted. That's it. There's not going to be arguments there's not going to be money judgments. There's not going to be orders requiring the landlord to do anything. None of that's going to happen. It's either eviction granted, eviction denied.
No, and the reality for a tenant who actually wants to force their landlord to do something is they have to file their own action.
Typically, yes. Yeah, correct.
Right. I mean, of course, you have to take all of your normal steps and processes, your 14-day letters, you know what I mean,
Yes.
or your 2-day letters, depending on the issues. But of course, yeah, I mean, you have to file your own complaint.
Yeah, usually.
Right.
Yeah, there are ways. So there's a mechanism. If there are issues with the property, habitability issues, it doesn't comply to code, there are ways to try to force the landlord to fix that. But ultimately, if the tenant has to send out a 14-day letter and say, these are the problems that I'm seeing, and you have 14 days to fix them. At the end of that 14, so the landlord's going to do one of two things, right? The landlord's either going to fix the problems, yay, or the landlord's not going to fix the problems, in which case the tenant will likely stop paying rent, and the landlord's going to move to evict them.
Right.
So that letter and that habitability issue is a defense in the case. But if the tenant wants to somehow affirmatively force the landlord to fix something, yeah, that's a separate lawsuit.
Right. And sometimes I tell tenants when they call my office that, you probably really want to leave anyways, right?
Yeah.
You know, I mean, and so really sometimes, these notices, because if it's a really bad situation, a really inhabitable situation, you really want to move, you know what I mean?
That's
so, and sometimes that's just the best thing.
And that's one of the great remedies. If the tenant sends out the 14-day letter and the landlord doesn't do anything, one of the tenant's remedies is, I'm terminating my lease and you have to give me my deposit back, and the tenant can just leave.
Right. And I think some people get confused about that as well, about if they can just leave, you know what I mean? If that's okay, they think I've got this contract, and if I leave, and of course there's a lot of threats about, the sort of termination fees, and I'm going to charge you all this, money. And of course, people worry about their security deposits
Sure.
and things like that. You know what I mean? But the reality of a contract is it's just a contract, and you can leave. It's okay.
Yes.
Sometimes you just need to take certain steps to make sure that your defenses for leaving are set up, right? So that way, if a landlord does try to come after you, either in an eviction court or say later on down the road to try to collect money, because they do have to send you that security deposit accounting notice, right? So if they send you those notices, you need to make sure you're setting up your defenses just in case they try to pursue you later. Because if they do it later, then you can say, look what I did, I don't owe them any money.
That's absolutely
And
right.
in fact, they maybe owe me money because I should get my money back. I didn't owe them XYZ. I did my proper disputing, all of those kinds
That's
of
right.
things.
Just tenants need to know their rights. They need to be cautious and careful about how they do something. They need to do it the correct way, and they need to save all that documentation,
Right.
save all the communication, save the letters, because they may need it one day.
Okay. And I can say, and I refer my clients all the time to the Civil Law Self-Help Center website, the Legal Aid Center manages. It is so much information and all of the steps that a tenant might need to take, right, about everything, every possible notice that you could get. There's so many forms and things. I love that website so much. I use it as a practicing attorney myself.
I actually wrote that website.
Oh wow, that's amazing.
It was a massive amount of work, and I think maybe it's in too much detail for most tenants, but if they're patient and they walk through it, it will tell them exactly what they need to do.
Right. Or if you're able to speak to someone, either over at the Civil Self-Help Center, call an attorney like myself practicing in tenant and labor rights, call the Legal Aid Center, speak to an attorney, speak to someone. They can help guide you through the process, right? Because the process in the eviction court is really not that hard if you just know what to do. And sometimes just having a little roadmap
That's right.
can be huge. And I know your guys' website definitely lays out everything that a tenant would need, you know what I mean? And sometimes just having that guidance would, is necessary. But it's not that hard. Sometimes the hearings are hard.
Yeah, and intimidating and scary, and but doable.
Correct. So when you're at a hearing, or a tenant's at a hearing, if they are representing themselves, should they bring evidence? What should they bring? What shouldn't they bring with them? Can they bring witnesses? What kinds of things can they bring with them?
They can bring anything they want to bring. They can bring witnesses, they can bring documentation, they can bring photos on their phone. The judges are really good about looking at photos that they've taken. Take anything that supports the defense the tenant's going to raise. The difficult thing, again, is the tenants need to really think about what supports my defense and what's kind of extra stuff that the judge really doesn't need to know about. But they should maybe even rehearse their case in advance to say, this is exactly what I want to tell the judge. These are the things I want to show the judge. Maybe make additional copies to give the judge so that they're prepared to tell their story. And I say rehearse because the eviction hearings are fast.
So fast.
Yeah, you won't get a lot of time, so you need to know what you want to say, be prepared to say it.
And there's going to be potentially a lot of legalese.
Yes,
The landlord probably will have a lawyer.
potentially.
A lot of times they do, or at least a representative of the landlord who has been through 1,000 evictions before, right? So they know exactly what to say and do and all of those kinds of things. But I would say the eviction court judges are very patient. They always want to listen, and they do want to look at your evidence if you have it. They won't just listen to a story, but if you have actual documentation, they will look at it.
And that's what I think is one of the advantages of attaching that evidence to your answer, because the judge already has it. The judge has already looked at it, and it's already there in front of the judge, and the judge already knows you have a story to tell, and it aids the process of telling that story in that really condensed time.
Sure. Another good reason to make sure that your evidence is attached to your answer is the appeal process,
For sure.
because maybe you can explain to our viewers a little bit about the appeal process. So say an eviction is denied and a tenant is insistent that this was just wrong. And sometimes the eviction court judges do get it wrong. It happens. What do they do then?
All right, so a tenant has the right to appeal now from the justice court. So all evictions take place in the justice court. Your appeal goes to the next highest court, which is the district court. So you're not going to the Supreme Court, you're just going to a district court judge. It's not super scary, but you've got to get that appeal paperwork on file fast.
It's like 5 days.
5 days.
5 days.
And you've got to do it before you get locked out, because once you're locked out, you're done. So you've got to get it on file in that 5-day period. Now there's a filing fee for that, $97 to file that appeal. If the tenant has had a fee waiver approved, then that will cover that $97. Otherwise, the tenant has to pay it. But you also have to post a $250 bond. The bond is the thing that stops the eviction from going forward while the case is on appeal. Now that $250 bond is not waivable. So a fee waiver does not touch the bond. The tenant has to actually take that money and give it to the court clerk. But once that happens, that appeal case, or that eviction case, anything that was submitted in front of the eviction judge will be sent up to the district court to review. Now, importantly, the district court judge is not going to take additional information. On appeal, what they're really looking at is, did the eviction court do the right thing or the wrong thing based on the information that was in front of it? So that's one of the great reasons to attach as much information as possible.
Because if it's not attached, then the district court judge may not look at it, or
Correct.
they won't have it in front of them to also look at to make a really informed decision.
That's absolutely right. The district court judge has the power, could grant a hearing and at least give you the chance to make an argument, but it's very possible that all of that will be decided without any hearing, solely on that paper.
Right, so a district court judge, when they get an appeal of an eviction, they can either decide it on the papers, and they will either affirm it or deny it based on the papers. They could ask for more briefing, or they could hold a hearing.
Correct.
So there's several steps that could possibly be taken in that appeal. Once there is that decision from the district court at that point, after, say, a tenant has gone through the whole appeal process, is there any further options that a tenant can take after that?
Not really. So there's no further appeal from the district court. That is your last court of appeal on an eviction case. There is the possibility that you could somehow file a writ to the Supreme Court, the Nevada Supreme Court, but that's tough because writs are totally discretionary, very few are granted, and filing that writ doesn't do anything to stop the eviction. So if the appellate court, if the district court judge says, no, the eviction was correct and I'm upholding the eviction, and you file a writ, it does nothing to prevent that eviction from going forward. So you would then have to file a motion asking for a stay, and it could get really, really complicated. So for all intents and purposes, for most tenants, that appeal is the end.
That's as far as you're probably gonna go, yeah. Oh man, so let's see, what else? Oh, I guess it's probably backtracking a little bit, I suppose, but you mentioned most 99% of evictions are summary evictions that we've been talking about. That's all we've been talking about is summary evictions. There are a little few narrow ones that go through the formal process, and that formal process being complaint, service, answer, hearing. Usually mobile homes, right?
So there are certain evictions that have to be by formal process, and one of those is mobile homes. It kind of depends. If it's an eviction from the mobile home space, it has to be a formal eviction. If it's an eviction from the mobile home itself, like I'm a tenant and I rent this mobile home, then that can be a summary eviction. So it gets a little complicated. Foreclosure issues, sometimes those have to be formal, so there is a bit of a distinction. Most times it will be summary eviction the tenants will face because it's easy. The landlords can do it themselves. They've done it a zillion times. They know how to do it, and it's quick, it's fast, it's painless. Formal eviction is a little more complicated.
Right. So if we're back in the eviction court, in front of the justice court judge, if the judge sort of grants the eviction, how long, what are the next steps, and how long does it take before an eviction may happen?
So if the justice court judge grants an eviction, what will happen in most cases is that eviction order gets issued, it gets sent over to the constable. That order really sits there until the landlord goes and pays the constable some money. The landlord's got to go pay a fee. But once that happens, the constable will go to the tenant's house, post that order on the tenant's door, come back 24 hours later, and lock the tenant out.
Right. Is there anything the tenant can do during that short window of time to stop the eviction?
Couple of things, actually. So one, they could appeal, which we've already talked about. If they disagree with the eviction, they can appeal to the district court. The other two things they can do, they could try filing a motion to stay. So a motion to stay is really asking the court for some additional time on the property to leave. And that's where tenants get confused. They hear motion to stay. Yeah, I want to stay in the property. It's a very temporary thing. It's totally discretionary for the judge, and the most the judge can give is 10 days.
Right.
But it does stop the eviction. When the tenant files it, the court clerk will call the constable, put a hold on the eviction until the judge decides that motion, which happens really fast, so it's usually a day or two.
Right.
The other motion they can file is a motion to set aside, and that's basically asking the court to get rid of the eviction altogether because something wasn't correct. There was some reason why the eviction shouldn't have happened in the first place. Now, that doesn't stop the eviction process going forward. So usually the tenant will file the motion to stay and the motion to set aside at the same time. On the motion to set aside, the judge can do a couple things. They can grant it, they can deny it, or they can set a hearing. So that one has a little bit more flexibility to it, but the tenant really has to make a solid argument.
Right, and a solid argument being something like,
I was misled by the landlord. Ideally, something that wasn't already raised at the hearing, right? So there's got to be some legal reason for the judge to get rid of that. Ideally, some kind of inappropriate action by the other party. That's always a good one. Something wrong with the process, maybe, but those are a little tougher.
right? And again, as you said, it's very, it's discretionary and not always given.
Yeah.
So it's not something you should rest your hat on.
No.
Never.
Absolutely not.
Really the best thing, file your answer, always.
Yes.
That way you get your hearing, because otherwise sometimes people get an eviction order and then they try to file the motion
Yes.
and it's too late at that point.
I will say one thing that we are seeing though. So we mentioned earlier about the CHAP rental assistance and the defense under AB 486. If you have a pending application, we have seen some tenants have success where they have done nothing in response to the initial eviction notice, failed to file an answer, the landlord got a default eviction, but then the tenant, constable goes out, posts the order on the tenant's door, a tenant frantically says, but wait a minute, I have a CHAP application pending, I didn't think I could be evicted. Well, that's only true if you notify the court about it.
Right.
So at that point, we have seen some tenants file that motion to stay and motion to set aside, and in that document, raise the defense, I have a pending CHAP application. And in some cases, the court that has successfully stayed that case until a decision is made on that rental assistance.
Okay, so that's good. So yeah, if you have that rental assistance, still do it. So even if it's a little late, if you have that rental assistance, still maybe take the shot.
For sure. And if those motions are unsuccessful, you could also try then appealing to the district court, and at least you'd have that information in the justice court file, in the eviction court file, saying, I have CHAP rental assistance.
Right, right. It's also important to make sure you notify your landlords of that assistance, of course. Make sure you have all of that in writing as well. Please don't do things verbally.
No.
As nice as it seems and as nice as landlord seems, if it's not in writing, it doesn't exist.
That's right.
Right? So emails, text messages work, photographs, videos, anything you have, documentation wise is important. I had a thought about when you were mentioning sort of about the additional 30-day notice that individuals who are disabled or have other reasons to ask for that notice. So if you maybe explain about that relief that a tenant can ask for, when that happens, at what stage in the game that happens, and then how they do that.
So one of the eviction notices that a tenant might receive is a 30-day no-cause notice. And a 30-day no-cause notice, unlike the other notices, it's not saying you're doing something wrong. It's not saying you're not paying rent, you violated your lease, you're causing a nuisance. It's basically just saying, I'm giving you 30 days because I want the property back. So if a tenant receives one of those notices and the tenant is elderly or is disabled, then the tenant has a statutory right, under the law, the tenant can say, I want an additional 30 days on that property. So they would notify the landlord of that in writing, provide some proof of their age or disability. They could attach their driver's license, attach their disability award letter, whatever they need to attach it. Send it to the landlord and say, I'm requesting my 30 days. If the landlord refuses to give that 30 days, then there's a motion they can file with the court, and the court will grant that 30 days. So that is absolutely something that anybody who receives a 30-day notice should be aware of. And it will say that in the notice. That is by law required to be in the notice, that you have the option to request this 30 days.
Right. So that's as easy as it is. You can, it does work, I think, with some other notices as well. I mean, if the plan for a tenant is to move, sometimes I know I have had tenants who have come to me and their plan is they want to move. They're elderly or disabled, they just need more time, so they've gotten some kind of notice, they're ready to get out of there. This letter, it does typically work. I have not, gratefully, have not had a landlord, have not had to go file one of those motions, but
That's good.
It doesn't mean it doesn't happen. Obviously, I'm sure you guys file them sometimes.
Yeah. Technically, a landlord's only required to give that 30 days, additional 30 days, if it's a no-cause notice. But I don't know that a lot of landlords know that. And also, hopefully, some landlords are just good people and are willing to give the additional 30 days.
Hopefully. And if you request it in writing and mention a statute, sometimes the landlord will go, okay, fine.
Yes, exactly.
Right? Let's see. We've also got questions here about retaliatory eviction.
Okay.
So what is retaliatory eviction and what is it?
Okay. So tenants will a lot of the time they will say, the landlord is retaliating me, he's trying to evict me because he doesn't like me, because I have kids, because my kids are loud. There can be all sorts of reasons, but really a retaliatory eviction is a fairly narrow thing. And really what it is if the tenant is doing something that the tenant is legally entitled to do. For example, they are complaining to the health department about a violation on the property. They are complaining to code enforcement about a violation on the property. They are calling the police because there's criminal activity on the property. If the landlord gets pissed off about that and tries to evict them, that is a retaliatory eviction. Or if the landlord is violating federal law somehow, if they are discriminating against the tenant based on race or sex or sexual orientation or any of those things that are protected, that's a retaliatory eviction. But just the fact that the landlord wants you out and doesn't like you, yeah, that's probably not.
Just because you haven't paid your rent and now you're getting an eviction, that's not retaliatory.
Sadly, no.
Sometimes it feels like it is, though.
Yeah. Oh, yeah. Usually by the time of the eviction, the relationship between the landlord and tenant is not great, and so there's a lot of animosity, and it feels like retaliation, but that's really a legal concept that requires kind of a certain thing.
Right. And the reasons that you can withhold rent, which I think a lot of people assume that just because they've had a lot of issues they can withhold rent, are actually a little narrow.
Very narrow.
So
yeah.
What are the narrow reasons you can actually withhold your rent?
So really, the big one is either the landlord is failing to provide me essential services. Essential services, they're things like heat, air conditioning in the summer, gas, water, or there are some habitability issue on the property, meaning the property doesn't comply with building code. There is some safety issue on the property. The important thing is, though, tenants cannot just unilaterally make the decision to withhold rent. They have to send the landlord a letter and notify the landlord of the problem. If it's an essential service issue, they send out a 48-hour notice, meaning, here's the issue on my property, you have 48 hours to fix it. For a habitability issue, it's a longer notice, so you send out the letter, it's a 14-day letter, landlord, you have 14 days to fix this problem. If at the end of that time period, you don't fix the problem, then one of the things I can do is withhold rent. Now the big thing though is, you have to send out the letter, and you have to keep the rent, right? It's not free rent, it's just I'm withholding the rent, right? Keeping the rent and not paying it.
And what should you do with the rent?
So you will take that rent, you will trottle down to the court when you file, because your landlord's gonna, as I mentioned earlier, your landlord's either going to fix the problem or evict. If the landlord moves to evict, the tenant will go down to the court, file an answer, and will give that money to the court clerk. And the court clerk will hold that rent until the judge decides what's going to happen.
Right, and that could be either the judge will order maybe something to be done before the rent is paid,
Yep.
or may discuss with the tenant about do they really want to move out, or something like
That's
that. You know what I mean? There could be a lot of discussions that might happen in front of the judge at
That's
that
right,
point.
absolutely. the whole process for tenants to try to force the landlord to fix something on the property is a really unwieldy process, and it's not a super effective process. It's a very blunt instrument that is difficult to work with, especially now during the pandemic. A lot of landlords, the tenants are paying rent anyway, and so if there's something wrong with the property, the tenant sends the notice and says, I'm going to withhold my rent. Well, that's not much of a threat if you're not paying rent anyway.
Right.
So during the pandemic, we've had a really tough time with habitability
Right.
issues.
I had a thought as you were sort of mentioning, people not paying rent and things like that. I know one question or one thing that came up a lot over the course of the last couple of years while rent payments were paused, sort of, is, do I still owe the money?
Yeah. So right now, nationally, there is about $20 billion of back rent owed. Huge amounts of money.
Wow.
So yes, the tenants absolutely owe every dime of that rent. That's why it is so important for tenants to access that rental assistance that's available from the federal government. That's free money. And we have seen awards from CHAP, $12,000, $15,000, $20,000. There's no cap on the amount that CHAP will pay. There's a time cap. They will only pay back 15 to 18 months, but there's no cap on the amount. So every tenant who owes back rent should make sure they tap into that money.
Right.
Because if they don't, what's going to happen is eventually they're going to leave that property and they're going to have this huge rental debt that they're going to get sued for. Right. That means a garnishment. That means a judgment against you. And there's no reason for it. Right. Get that free money, tap into it now. It's an easy process. Get that paid and walk away from that landlord-tenant relationship free and clear.
And you mentioned that there's a time limit on that. So the time is slowly probably running out for some people, you know what I mean, or quickly really running out for some people to actually secure that payment and make sure that they don't get that judgment later.
So the time limit I was referencing is there's a time limit on how much CHAP will pay back.
Got it.
So if I applied today, CHAP would say, okay, we will pay up to 15 months of your back rent.
Got it, okay.
And if you apply multiple times, that you can apply multiple times in 3-month increments to reach that 15-month limit, but that's your limit. But as far as when to apply, there is still plenty of money there. So every tenant who owes money and is eligible, meaning you've had some kind of COVID impact. Everybody's had a COVID. There's no person we talk to who has not had a COVID impact.
Of course.
So you have to have a COVID impact. You have to be low income, which of course they are because they are not able to pay their rent.
Right.
Apply for CHAP. You do it all online. It's a little bit of a hassle. You have to provide some documents, but you could probably do your application in 30, 40 minutes. And the important thing is just follow up. If CHAP emails you, if they call you, if they send a message to that account, you check your account every day. And if they ask for anything, you provide it to them.
Of course.
And then you get a check. You don't get the tenant doesn't get the check. Sorry, tenant.
If only.
The check actually goes directly to the landlord to pay off that back debt. But there are some cases where if the landlord is refusing to take that money, it will go directly to the tenant.
Why would a landlord refuse money?
Oh my God, Alexis, this is the big question we've been asking.
Why?
Why would some landlords say, I just want the eviction, I don't want the money? Well, so you would rather have the tenant walk away.
What if you could get both? Because they probably want to leave too.
Because realistically, the landlord's never going to get that money.
Right.
They will never get that money.
Right.
So it makes absolutely no sense. One of the things we're thinking, well, two things. One, potentially the landlord hasn't been declaring that income. And so they have to sign something to CHAP and they have to issue a tax document to receive that money, and they don't want the IRS to know that.
Okay,
So that's one option.
Definitely a possibility.
The other option is housing prices have gone up so fast that the landlord just wants the tenant out because they want to sell that property and they want to make some bank.
Oh, we could probably talk for hours about the rental market right now too, but I think that's probably beyond the scope of our time.
And there's nothing good to say anyway.
True, but I think one thing to say is that, a landlord cannot force you out just because, or I guess they can't just make you leave
No,
because they want to sell the house.
that's absolutely
So
right.
that is important to say. They have to go through these processes.
That's absolutely right. Two other things as far as the rental market goes. So a couple of other bills were passed in the last legislative session. One of the bills automatically seals any non-payment eviction that is issued during the course of the emergency. So we are still in a state of emergency. That means that any eviction for non-payment that is issued, that court record is going to be sealed, which is so important right now because tenants are struggling to find new apartments, and if they have an eviction on their record, that can kill them.
Yes.
One of the other bills that got passed was an extension of the notice that a landlord has to give if they're going to increase the rent. So it used to be landlord could give a 45-day notice. Now it's got to be a 60-day notice. So a 2-month notice before that rent increase can go into effect. But I want to be clear to all tenants, if you have a valid current lease, the landlord cannot raise your rent. Do not sign anything. They will put a paper in front of you and say, oh, I've got to raise your rent. Do not amend that lease. Do not do anything.
No, please do not
Yes.
sign anything in the middle of your lease that changes your lease term, and that will change your lease term. They cannot change, yes, if you have a written contract that has not expired, they can't do that. They could, within 60 days of the end of your
Yes,
lease,
they could.
send you a notice and say at the end of your lease your rates are going up, but they can't do it at, say, month 3 or month 4
Yes,
or month 5
that's right.
if you have a year-long lease.
That's right.
Oh, these landlords.
And if you're in a position where you're unemployed, you have no money coming in, you've maybe applied for CHAP, and you have no likelihood of income anytime soon, be very careful about signing anything. Do not commit yourself to a rent increase. Do not commit yourself to a repayment plan. Do not commit yourself to anything if you will not be able to do it.
Right, and it is okay to go month to month.
Yeah, for sure.
Because then when you're month to month, in order to get you out, as long as your rent is paid, as long as there's no other violations, you have to have a 30-day notice.
That's right.
The only way to get you out if you're month to month is to serve you a valid 30-day notice.
Yep.
That's pretty nice too. So, so some tenants will file their tenant affidavit, they file their $71 filing fee, and then nothing happens.
Yes.
Then what?
Yeah. So remember we talked about earlier that the eviction court can award money, right? So there really is no way I know of for a tenant to get that $71 back. They have to pay it to file that answer and protect themselves, and they absolutely should do it. But there's no guarantee.
Well worth $71.
Well worth $71. There's no guarantee that you're ever going to see that money again. So after the notice period, let's say you get a 7-day notice, that's tenant's period to file. After that, the landlord can file the complaint to try to get the eviction. If the landlord doesn't file anything in 30 days, takes no action in 30 days, that case just goes away. And the court will seal that case, so nobody can ever see it. But that means the tenant has paid $71. Now, the only way I can think of that a tenant could potentially get that back is to sue the landlord in small claims somehow and say, that was a wrongful eviction, you shouldn't have done it in the first place, and I should get that filing fee back. But the fee to file in small claims would probably not make it worth trying to get that $71, unless your landlord, we have seen situations where a landlord every month, like clockwork, on the first of the month, will give a landlord an eviction notice, and the tenant will have to go down and file, and it's just merry-go-round that they're on. If your landlord has done something really abusive like that, and you want to pool all that money and sue in small claims for it,
Might be worth it.
take a shot. Yeah,
Might be
yeah.
worth
I have
it.
no idea whether you'd win. I've never seen it done, but try it.
I mean, I would make an argument in a case like that too, that there is other breaches of contract going
sure.
on, and breach of maybe the implied covenant of good faith and fair dealing, and breach of the covenant of quiet enjoyment.
Kitchen
and
sink. Throw it all in there.
there would be a lot of reasons I would say that that's probably wrongful, and you
Yes.
might be entitled to even maybe more than just your $71 paid each time. But
It actually reminds me, so let me mention this too. One of the other statutes that was passed So tenants now have a 3-day grace period for payment of rent. So a landlord,
Whether or not it's in the contract or not.
whether or not it's in the contract or not, and the statute trumps the contract. So even if the contract says something differently, the statute trumps. So,
Unless maybe it's longer. I would,
yeah, longer's good. Yes.
if it's longer than 3 days, if your contract says 5, you can go by the 5 days. But if it says
Yes.
nothing, or it says 0, or it says 1, you actually have 3.
Yes, so a landlord cannot charge you any late fee until 3 days after the actual due date of your rent.
And what about the cap on late fees?
So late fees are capped at, I think it's 5%?
Yes.
5% of the base rent. So anything beyond that is unenforceable, cannot be collected, it's a violation of the statute. And that's another thing for tenants to watch when the landlord gives them an eviction notice for non-payment of rent. Rent means the base rent you pay every month. I pay $500 a month in rent. The rent you think of as rent. And it means late fees, but it doesn't mean anything else. If there are other fees that the landlord is charging you, that is not rent, and that's potentially a great defense for that eviction.
Right. And looking at those notices at the eviction stage is really important, because the details, if they're not there, the judge can and a lot of times
Yes.
will deny an eviction. So if you have a landlord that maybe doesn't use one of Legal Aid Center's forms, they really should, landlords, landlords, use the Legal Aid Center's forms. They're available, you know what I mean?
They're free.
And they're
Yeah.
free, yeah, so use them, and they're fillable. You can just type in your information, it's very easy. Again, the website is wonderful. But if, a landlord has just handed you, say, a handwritten notice, or posted a handwritten notice, and it doesn't have there's a lot of things that the statutes say that these notices have to have. So if that notice is not complete, that in itself is a defense.
Yes, and
And
now
a very valid one.
under AB 486, there are additional things that the landlord has to provide. So the landlord has to notify the tenant of the availability of rental assistance, and it has to notify the tenant about the potential defenses under AB 486 based
About
on
the
rental
30-day
assistance.
additional notice for being over 60
Yes.
or disabled.
So-
There's a lot of things that have to be in there.
Yes.
And if any of them are not, and it applies to you particularly,
Yes.
then you're going to be able to get an eviction denied.
So the notice is getting really, really long. It's like 3 pages long now. But that's good,
Right. Although I guess it can be confusing for tenants
Yes.
because there's so much information in it. But hopefully everything we've given here is a lot of help. I know I've learned some things today, for sure. You know what I mean? And I'm grateful. Again, grateful for your guys' website, because I use it as a practitioner as well. So, because sometimes it's hard to remember exactly what it is that has to go on, and sometimes the steps are a little bit different in every case. But once you know that the roadmap is there and how to follow it,
Yes.
it's not so bad, right? Having that
And on that point, let me mention one other thing to tenants. So when you receive an eviction notice, yes, it is confusing, and yes, the notice can be complicated and long. There really is no reason not to file an answer. So we have now developed a guide and file program, which is basically like a TurboTax. So from the comfort of your own home, you can sit down at your computer, you can pull up this program, it will ask you some questions, just like TurboTax, you type in your answers, it will populate the forms, it will get everything ready to file, and if you live in Las Vegas, you can give it your credit card number and file from your home. So there's no reason, you don't even have to go to the courthouse, no reason not to file.
Henderson and North Las Vegas, though, you do have to go to the courthouse.
Yes, but you can still use that program to get your documents prepared, then take those documents down to the courthouse.
Look how easy they're making
So
it.
easy.
So easy. And no reason not to pay that $71 and get an answer
Yeah.
on file, because otherwise it's that automatic eviction.
Correct. Yeah, that's what we don't want.
No, we don't want that at all. Well, I don't know if I have any more questions. All right. So thank you very much for your
happy to
time.
help.
Thank you so much. I really appreciate it. I know our Nevada judges, Alex Falcone and Brittany Falcone of our Nevada judges, really appreciate it. And I am Alexis Brown. Thank you for everyone watching our Nevada Judges Perspective series today.